saying. But now's not the time to ask me to be lenient. This is case number 25CR43170, the State of Ohio versus Derek Banks. Mr. Banks is before the court with his counsel, Mr. Lewis. Ms. Tranter, on behalf of the State of Ohio. Ms. Tranter, we are set for plea. What are we doing?
Judge, we have presented Mr. Banks with an offer which includes a plea to the felonious assault, a plea to the aggravated vehicular assault, as well as the fail to comply with this order or signal of a police officer and the receiving stolen property for a combined sentence of 6.5 years in the Department of Corrections. My understanding as we sit here today, I do not have a signed plea form. I will tell the court, as you're probably aware, I believe this is the 5th time we've been here on this particular case. The offer from the state expires today at the end of this hearing. If Mr. Banks does not want to accept that, then we're going to have to get a trial date.
All right, I'm sorry, could you tell me again what the offer was?
Yes, the total offer is 6.5 years, so it would be 3 to 4.5 on the felonious. I think do you have the plea form there, Mr. Lewis, in front of you?
Yeah, sorry.
Just so I can tell him how we structured it. Okay, yeah, 3 to 4.5 on count 1, which is the felonious. Count 2 being the aggravated vehicular, 18 months. Count 4, 24 months. And count 5, 18 months. All counts except for count 5 are to run consecutive to each other. Count 5 would run concurrent.
All right.
So the maximum term under Reg and Tokes would be 6.5 to.
May it please the court? Your Honor, for the record, Carl Lewis, on behalf of Derek Banks, in the courtroom, is present with his mother and father. I've had an extensive conversation with Mr. Banks, with his mother, with his father. The most difficult thing, Your Honor, for this young man in the court does not, I explained that to him, get into plea negotiations. Ms. Tranter has been working with me, and I appreciate her patience. This young man has never, ever been in trouble before, and the prospect of the 6.5 years is startling to him. I've cautioned him and advised him that it is in his best interest to accept this plea resolution. He was asking again for more time, and we could meet again and again. His concern, as well as his mother and father, they understand this is a serious offense. They understand that the charges are significant. It's just difficult for mom and my client to accept that he has to go to the penitentiary for 6.5 years. I've explained to him that if the court was gracious enough to speak with us about the F1 felonious assault at the last hearing, it was our intention at that time to maybe try the case until we reviewed the law with respect to purposeful versus knowing. And my client understands what the instruction would be to a jury, what this honorable court would consider if this case were to go to trial, has not made a decision whether he's guilty or not guilty, but clearly it is my opinion we would not prevail on the failure to comply, the vehicular assault, or the receiving stolen property, and that carries a potential maximum of 8 years. So I've cautioned my client that I would ask the court for maybe 2 more weeks to consider this plea. Ms. Tranter has made it abundantly clear that the state will not offer this if the plea is not taken today. And I explained to my client, if the court denies our request today, what is your pleasure? And it is my expectation and hope that he would take the plea if the court's not going to grant us another 2 weeks to consider the plea. And I believe his mother wanted to address the court regarding a little more time to discuss the plea with her son. Yeah, can
you come on up? Step up here to the table.
Sir, you can stay right there.
I told him,
Ma'am,
don't touch your son.
I need you to stay behind that table. Thank you.
Take a deep
Swear and
breath.
state your name for the record.
Taisha Hill.
Okay, what would you like me to know? Again, I apologize for the formality of this, but as the judge, I'm not allowed to have contact with people outside the attorneys on any particular case. So when someone sends me a letter or wants to communicate with me, it's either on the record or the letter that comes to me goes to the attorneys first before I ever see it. And it's just to maintain my impartiality. I hope you understand that. Okay, now again, what would you like me to know?
Like his lawyer was saying, like he never been in trouble before.
Okay, here's the thing. I'm going to stop you right there because, again, he's not been found guilty of anything, okay? I understand he's being held in jail in lieu of posting bond, and I get all of that. But right now, now's not the time. I don't know enough about him. You know a lot more than I do. The attorneys know. I know what he's charged with and what the general allegation is. I do not know the specifics of the case, and it's that way for a reason, okay? If you're asking me to be lenient on him, right now, that's not my job because, you know, the first thing that has to happen is he would have to be found guilty of these offenses. And that's where the attorneys come in, or the jury would make that finding. I'm not here to make that finding right now. It sounds to me like you want to do some sort of presentation with regard to me being lenient on him with regard to a sentence. But that's way down the road still. If you understand what I'm saying, I'm not here to sentence him today. He's not even been found guilty of anything. So I don't want to get way far ahead of myself. I understand what Mr. Lewis has said. He has no prior record. Obviously, he started off here with these charges are very, very serious, saying it. But now's not the time to ask me to be lenient. You're being recorded still.
I'm good. I think we're good, Judge.
Okay.
So do you want to do?
So I don't do a PSI if I do.
Right, you got to.
The maximum term sentence is automatically calculated to be whatever number the court selects between 3 and 11 plus 1/2 of that number. So if the number is 3 as the minimum term on that offense, the maximum term is 3 plus 1/2 of 3, or 1.5, which would be 4.5. So that on that offense alone is 3 to 4.5. But I must advise you that the maximum, the longest minimum term on this is 11 years, which makes the longest maximum term 11 plus 1/2 of 11, which is 5.5, which would make the maximum term 16.5. Do you understand that?
Yes.
All right. Then you'll also be receiving, on the other offenses, you'll be receiving sentences. On the felony of the 4th degree, you could receive up to 18 months in prison. On the failure to comply, up to 60 months in prison. And on the receiving stolen property as a felony of the 4th degree, you could also receive up to 18 months in prison. And you understand that the length of the sentence could be affected whether the court runs those sentences concurrently or with each other, or consecutively one after the other. You understand that?
Yes.
Okay. So the longest minimum term sentence that you could receive is 19 years, and that's if I gave you the maximum term on each one and ran them all consecutively, okay? And the longest maximum term sentence would be the 19 plus the 5.5, or 24.5. Do you understand that?
Yes, sir.
There is a rebuttable presumption that you would be released after you serve your minimum term sentence, or a presumptive early release date, whichever is earlier. Now, the Department of Corrections may rebut that presumption through an administrative hearing process and thereby maintain your incarceration for reasonable periods of duration up to the maximum of 24.5 years. The criteria for the Department of Corrections to rebut the presumption and to maintain your incarceration after you serve the minimum term or presumptive early release date, whichever is earlier, include the following. Number 1, during incarceration, you commit a rule infractions that compromise a prison's security, compromise safety of staff or inmates, cause or threaten physical harm to staff or inmates, or you commit a violation of law that was not prosecuted, and any infractions or violations which demonstrate you have not been rehabilitated, and or that your behavior demonstrates that you continue to pose a threat to society. Number 2, regardless of the classified security level at the time of the hearing, you had been placed in extended restrictive housing within the year preceding the hearing date. Or number 3, at the time of the hearing, you are classified by the Department of Corrections as a security level 3, 4, 5, or higher.
Yes, sir.
Ms. Tranter?
Your Honor, in addition to the facts that are alleged in the indictment, these incidents occurred on November the 15th of 2025. Warren County, state of Ohio. On that date, the defendant was seen operating a vehicle at a high rate of speed by Trooper Aldeta. He did pursue defendant, activating lights and sirens. Defendant continued to operate the vehicle at a high rate of speed, reaching speeds in excess of more than 100 miles per hour, weaving in and out of traffic. Multiple agencies did end up becoming part of this pursuit, including Middletown, as well as Franklin Police, who ultimately performed a pit maneuver, and the defendant's vehicle was able to finally be brought to a stop. During the pursuit, he did collide with a civilian vehicle, causing injuries to the driver of that vehicle, who was transported to Miami Valley Hospital for her injuries, serious but not life-threatening, as well as there was a collision with a Middletown police officer in his vehicle, and the vehicle that the defendant was operating was found to be stolen.
Mr. Lewis, anything on those facts?
Respectfully, Your Honor, nothing on the facts, nothing more to add, stipulate to what's been read into the record by the state.
Mr. Banks, did you hear the statement that she read?
Yes, sir.
Do you admit and acknowledge that what she said is true?
Yes.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we went over.
Yes, sir.
What is your plea, sir?
Guilty.
All right, the court's going to make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we have discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty.
Yes, sir.
Ms. Tranter, anything before I sentence him?
Judge, we would ask that you do impose the agreed recommended sentence in this case, in addition.
All right, Mr. Lewis, anything before I sentence him?
Judge, just briefly, the court has heard through our numerous discussions that this young man is never thought he would be here. He's highly intelligent, graduated, was in college, chose to engage in some activity that has landed him here today. And I told him as we were preparing for this case, you hit the grand slam in terms of criminal offenses. And unfortunately, and I appreciate the state of Ohio, Ms. Tranter, in terms of our negotiations coming to this number, I was desperately looking to get a lower number for this young man. I continue to pester the state, this honorable court, in terms of reaching a sentence that was lower. He's 20 years of age, never been in trouble, going to the Ohio Department of Corrections, and wants to desperately get back to his mother, his father, his siblings. And it's been difficult for him to comprehend that he's going to spend, if the court follows the recommendation, 6.5 years in the Ohio Department of Corrections. He will do everything he can to make himself better by education, anything he needs to get involved is positive. It's been an honor for me to represent this young man, and I'm hope that, as painful as this is for he and his family, that he can return to our society a productive, law-abiding citizen. And with that, I would remain silent.
Mr. Banks, is there anything you'd like to say?
I just want to say I want to apologize to the family that I involved in my foolish actions. I want to apologize to the officers and my family for letting them down. I never intended to cause any harm. I just panicked, made a stupid, young, dumb decision.
Ma'am, I'm going to give you another opportunity. If you would like me to know something in addition to what's already been said, if you'd like to say something, now would be the time to say it, because I am going to sentence him now. I need you to come forward. All right, the court has considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court has also considered the agreed recommended sentence of the parties and will find it to be an appropriate sentence. So on count 1, the felonious assault, the court will order you to serve a minimum term sentence of 3 years and a maximum term sentence of 4.5 years. On count 2, the court will order you to serve a sentence of 18 months in prison. On count 4, I'm ordering you to serve a prison sentence of 24 months in prison. Count 4 and count 1 by law must be served consecutive to each other. The court is also ordering count 2 to be served consecutive to count 1 and 3. The court finds that the consecutive sentence is necessary to punish the defendant. It is not disproportionate to the conduct or danger posed by the defendant, and these offenses are part of a course of conduct that the harm caused was so unusual, the single prison term would not adequately reflect the seriousness of the conduct. And on count number 5, the court's going to order you to serve 18 months in prison, that to be served concurrent with counts 1, 2, and 4. You have 157 days jail time credit. The court is going to order restitution in the sum of $500 to Eric Lane. Other than that restitution order, the court's going to find that you're indigent for the purpose of other fines, costs, or financial sanctions.
Thank you, Judge.
I am going to order an operator's license suspension for your lifetime. Now, I know I'm saying lifetime now.